Um, Thank you very much. I benefited very much from the discussion so far, and I have completely changed my talk. I have rewritten during the day, so I will speak extempore, and you will excuse me if it will not be a very formal talk. I'll try to bring my experience as a law professor, and I hope this may help. And the question I moved from is, which is the aim of affirming connectivity as human right? Which is the aim? It is not a very simple question, and there are at least two dimensions in order to answer this question, a legal one and a political one. The legal point of view can be summarized in three positions. The first one, the formal thesis, which has been mentioned by Professor Prodi at the beginning this morning. The formal thesis is the following. Connectivity is not a human right. It is an enable of rights. It's not a right in itself. This is a very strong position. It has been affirmed many times by many important authors. And it's difficult to reply to this position. It is true that technology is an enabler of rights. Internet is a tool for obtaining something else more important. One may also say that, and it has been said, that human rights are instrumentally necessary things for membership in a political community, and that although internet access is instrumentally valuable for membership, it should not be seen as a human right in itself because it is not necessary for membership. Another position is to see the rule as a programmatic rule. More or less, the state should promote access to internet. And this is quite a common position. We can read that in many national legislation and also in some UN resolutions. And then there is a more substantial position, very close to the European one, mentioned before this morning by Roberto Viola, a substantial rule. The recognition of universal service and, of course, a way of funding the recognition of the access as a universal service. This more or less is the summary I can try to draw from a legal point of view. But there is also another way to consider this topic. There is another point of view, and is the following. What if connectivity is denied? So on the other way around, not talking about connectivity as a right, but considering the hypothesis in which connectivity is denied. Well, if connectivity is denied, then a social dimension, an economic dimension, and human dimension is denied. So in this way, if you put the question in the topic in this way, connectivity is a prerequisite, is a precondition for the exercise of many rights, and there are no doubt. It's a precondition to exercise many human rights online. For instance, freedom of expression, freedom of assembly, the social development, the development of economical activities, and so on. So probably what is needed is a political engagement in order to assure the precondition. This was done partially in 2012 and 2016 in UN by UN Human Rights Council. In 2012, it was affirmed that the same rights people have offline must be protected online, in particular freedom of expression, that the global and open nature of the internet is a driving force in accelerating progress, and UN called upon all states to promote and facilitate access to the internet and international cooperation. In 2016, UN affirmed also the importance of applying a comprehensive human right-based approach in providing and expanding access to internet, to bridge a gender digital divide, to take appropriate measures to promote design, development, production, distribution of information and communication technologies and systems, so with a focus also on digital divide. So going back to the question I posed at the beginning, which is the aim of affirming connectivity as human right. Well, I think that the answer is to remove substantial obstacles. Law can play a role in removing obstacles. Affirming a rule can be useful in order to remove substantial obstacles. This is a role legislation played in many, many cases. Of course, economic investments are needed, education is needed, but probably, from my point of view, best role law can play is the removal of some obstacles. But there is also another side of the coin. Where there are rights, there are also duties. And of course, in many resolutions, resolution I mentioned before, UN condemns human rights violation and abuses, measures measures to prevent access to information online, combats violence, and so on. In conclusion, it can be affirmed that the same rights people have offline must be also protected online, but it must also be affirmed that the same duties must be performed online as well. Thank you very much.